Good evening. It's Matt Doran here from the CIOB. Thanks for joining us. I hope you've had a lovely break. For those that had the whole 10 days, well done, congratulations. It was a bit strange coming back into work yesterday, but it was a lovely break, and I hope everyone has had a good Eid. Welcome back. Thank you for joining us immediately after Eid for this event. It's a very well populated event in terms of interest. Dr. Waleed and Dr. Salwa, really two high profile in terms of their knowledge, experience. Very, very delighted to have them both here today. Our Abu Dhabi hub have supported this event in terms of getting it together. Thank you very much for Sabah Qureshi for pulling this one together for us. But I know it's been fantastically supported, particularly across our Arabic network recently as well. We've just come back from Cairo. We've got a lot of the Egyptian network working for us, and it's a very well attended event. So thank you very much for registering. I'm just going to tell you a few things. If you would like, please tell us where you are in the world. I'll have a quick look at the chat in a moment. If you're in anywhere exciting, I'm sure the guest speakers would be really thrilled to see where people are coming from. So we've got Egypt, which I was expecting, Qatar, Oman, Dubai, UAE, fantastic. Keep going, keep going. Anyone further afield? Wow, Canada. Okay, so that's pretty impressive. The time difference is pretty serious. So I'm guessing you're middle of the night. London, Saudi Arabia, Kuwait, fantastic. Bahrain, Tunisia. Wow, this is almost sounding like the Olympics. Excellent. Well, thanks very much for joining. As I said, we generally have quite a good range of countries that support these events. Really thrilled to have you here. And just to answer a question that's come up straight away, we are recording the event, and tomorrow you'll receive a PDF with the presentation as well. Please don't tune out yet, because unfortunately, if you tune out now, you won't get a chance to participate in the Q&A. If you've got a question, please put it on the Q&A tab, which means we can track it. If you put it in the chat here, it moves too quick for us, so we might lose it. So please take the time to find the Q&A tab and put your questions there, and we'll get through as many as possible at the end. We most likely will not answer every question, but we'll do our best to answer as much as we possibly can. Okay, so I'll just give you a bit of information about where we are with CIOB at the moment and what's up and coming. We've got a few events through August. It's a bit of a quiet month for us by our standards. We've got some workshops. We're particularly delighted to have our Arabic introduction to CIOB in there on Monday the 16th. This is going to be supported by the Cairo Hub Committee, and it's going to be delivered in Arabic. So if you're interested in CIOB, but you're not sure what it does or the benefits, then we've got some Arabic speakers available to talk you through it. That's going to be a really good workshop. We've never done that before. And we've got an exciting guest speaker that I'm just going to put a few slides on that through in a second. But one of the things we want you to just be aware of is there's a big event coming in Dubai in September, face-to-face. We as CIB are going to be exhibiting at the event. We're very excited to do it. We've just done Cairo. I know a lot of the audience perhaps even met us there. It's brilliant to see you. But if you do get a chance to join us in Dubai for that, that would be really, really good. So please tune into that. You can register for free. Here's the guest speakers for the Arabic introduction CIB. Wael, Ahmed and Moataz, they make up the Cairo Hub Committee alongside Muir Smith from Leeds. And they'll be talking through the benefits of CIB and why you should join. And then this is our next guest speaker, David Yek, who is a chartered architect. And he's going to give a bit of a different perspective on your construction contracts through the architect's perspective. So he's a very well-known speaker, great following, and he should be definitely a person to tune into. I must say hello to Connor from Northern Ireland, who is the Abu Dhabi Hub Committee Chair as well. He's just posted. Thanks for your support, Connor. We have lots of courses that you can take a look at. If you use a QR code, you can go straight to the links. So please browse through, see what you like. We've got this fantastic FIDIC course, which is to do with our aim to put more local content into our CIOB Academy. We're doing a lot of work on here with Justin Hall, our Academy training manager. This one kicks off tomorrow, but there's loads of courses available, should you be interested. And then finally, just in case you do want to get in touch, or even better, if you want to follow the WhatsApp group that's that we're sending messages out on constantly, please use this QR code, get in touch with the team. We're now 4, Matt, Jessica, Lauren and Justin, if you need anything at all. And then just before I go over to the guest speakers to hand over, this is a network of 1,800 people that you can join. It's all free. We encourage you to follow it because everything that we do here at the CIOB MENA is on there and advertised fully. So please check that out. And then finally, I mentioned Connor, I mentioned Saba from the Abu Dhabi Hub Committee. We're very pleased to have our members support us across the region. We've got very strong hub committees across the region now. And this particular event's been put together by Abu Dhabi Hub, but very much supported by everyone here. So big shout out to all the names on here, but particularly the Abu Dhabi Hub for pulling this one together. Okay, that's me just about done. I know you all tuned in and registered to listen to our guest speakers. So without further ado, I will hand over to you, Waleed, to put your share for your presentation and start with your webinar.
Thank you, Matt. Let me share the screen now.
Really good response from the audience. We've got well on the way to 100 people here tonight. So thank you very much, everyone.
One second.
I'm just looking back. Did we have anybody from further afield? Yeah, I think Tunisia. Oh, we have Manchester, Tom in Manchester as well. So yeah, excellent crowd tonight. Okay, Waleed.
Okay, so thank you, Matt, for this introduction, and it really gives us great honor to be presenting at this CIOB event. It also gives me a great privilege to be presenting with Dr. Salwa Fawzy, this interesting topic, actually 2 topics in one presentation. So we'll first start by introductions. Introduce Dr. Salwa, although she's really someone who does not need any introduction whatsoever. Dr. Salwa, of course, has her PhD, and which really centered on the application of FIDIC in MENA region countries. And also, she has an LLM from Robert Gordon University and Bachelor of Science in Construction Engineering from the American University in Cairo, and she's a fellow at the Chartered Institute of Arbitrators. She is currently the Commercial Director in El Suidi Industrial Development, Contracts and Procurement. She's also an instructor, a well-known instructor at the American University in Cairo, and she has over 20 years of experience in construction contracts and claims. And recently, she's known for that well-published book, Practicing FIDIC in Civil Law Jurisdictions, Application of Time and Additional Payment Provisions, which is based largely on her thesis that I mentioned in the PhD. And this is actually the book that Dr. Salwa has published, which is really a very recommended reference. By means of introduction, my name is Walid. I have a PhD from the University of Salford on a construction law related topic, time bars. I also am privileged to have graduated also from the Robert Gordon University, Construction Law and Arbitration, same university as Salwa. I have an MSc and a BSc in Construction Engineering from the American University in Cairo. So as you can see, Dr. Salwa and I have several commonalities. We're both AUC graduates and we're both RGU graduates, and we're both fellows from the Chartered Institute of Arbitrators. I have been working in Hill International Africa, based in Egypt, since 2008. I'm currently the contracts director. I'm an adjunct assistant professor in the AUC, the American University in Cairo, in the construction engineering department. I also in the Chartered Institute of Arbitrators. I'm vice president and education training officer there, and also I am also affiliated with the Association for the Advancement of Cost Engineering International, AACE, which is based in the US. And I am also the Egypt representative for the Dispute Resolution Board Foundation, the RBF, which really promotes the use of dispute boards internationally. And I have over 20 years in construction contracts and claims management. Now, as an outline for the presentation, first we'll start with some housekeeping for the attendees' participation. We want this to be really an interactive webinar. It's not just lecturing, but we want your active participation. And I'll explain that in a minute. And then we'll go with the objective of this webinar. Then we'll go into the constructive acceleration. We have really two issues. We have the constructive acceleration and pacing delays. And for each one, we'll address first theoretically each topic. When I say theoretically, I mean, because these are really common law topics and specifically more US case law issues. So we'll talk about the theory first. I'll handle that, and then I'll hand over the floor to Dr. Salwa to discuss the application from the Egyptian civil law perspective. And when we say Egyptian civil law perspective, as we know, the civil laws of the MENA region, predominantly most of them have actually were affected or influenced by the Egyptian civil law. So actually when we say that, you can always extrapolate the applicability in these other jurisdictions. And then we will end with the questions and answers. And as Jessica mentioned in one of the messages, please be sure to insert your questions in the Q&A box. Now, for the housekeeping for attendees' participation, what we'll do is for participation, they will start with some poll questions, simple poll questions through Zoom. And then we will have some questions we'll be asking throughout the presentation, which you can insert your answers through the chat box, basically. And we'll just take a look at your responses briefly through the chat box. And there may be instances where you need to raise your hand. And if you don't know, then I think you click on the panel, the participants button, and I think there's a button there for raising the hand. And then, of course, at the end of the lecture, we have the Q&A session, which we'll strive to answer as much questions as we can. Now, really, the objective of this webinar, as we all know, there are some common law concepts in construction law. So you have these terminologies like constructive acceleration, like pacing delays, like concurrent delays, time bars, and loss of productivity, disruption claims. And there are cases in the common law jurisdictions about these, but when it comes to civil law, we just have civil law principles. Civil law is just the civil codes are just an embodiment, a collection of rules, if you will. So what we're trying to do is really try to fill in this gap by trying to merge both. So we have the common law principle, and then we see what are the pertinent principles under the civil law, and we try to make sense of them. So it's really it's an effort that we encourage that further effort to be built on that. So we to explore more common law concepts in construction. So we'll start now with the poll questions, and I'll hand this over to you, Matt, for the polls.
Yeah, sure. Let me just launch the first one.
Okay.
So, You should see it on your screen now. And Waleed, I took the liberty to add in the I'm slightly aware, just in case we've got people sitting on the fence. So we'll just see in a few minutes. Really,
Yeah,
that's great to see you voting. If you haven't already, we're going to do a few of these polls. Yep, still coming in. Looks like it's around about there. Okay, here you go. Here's the results.
Okay, so that's interesting.
Yeah,
The majority have heard of the term construction acceleration, and I mean, there's quite a few also who are slightly aware of this provision. Okay, we can go to the next one moment.
Okay. You want the second question now, Waleed?
Yeah. We'll take the second and the third.
Okay. Similar thing. So are you aware of the term pacing delays? Let's see what we've got here. Again, good active audience. Almost 100 people in today, so please click away. Hopefully you can get this. And slightly more interesting one, this Waleed. Okay, a few more coming in, and I'll call it there. There you go.
Okay. Yeah, I think you're right, Matt. Actually, before this presentation, I had the feeling that there's more awareness of pacing delays and more interest of pacing delays, actually. So that I think the results confirm that. Although it's interesting is the yes and the no are almost equal. So it's almost like it's almost even.
Yeah. Okay, third one. So, and this is, have you used them? Let's have a look.
Yeah, so the intent of this question is: have you, in your work, have you used these concepts? So if you're say a project manager, you're working in a project management firm, did you evaluate a claim, for example, that has these concepts? If you're a contractor, did you use any of these concepts in your claims? This is the purpose of the question.
I think this one will be quite powerful in terms of how much education you're providing today as well, Waleed and Salwa. We'll see. A few people taking a little bit longer over this one, so I'll give it a couple more seconds.
Okay.
Great, we'll call it there. And there's the results of the third poll.
Okay, this is actually what I expected. I thought that there would be more people who have not really applied this. So a lot of people may have known about them, heard about these concepts, but did not apply them yet. Dr. Salwa, is this what you also had expected?
No, I expected less number who have applied these concepts, as you just mentioned.
Yeah.
It's known for some, but it's not really widely applied.
Yes. Okay, thank you all for the participation. And we'll start with constructive acceleration. As I mentioned, we have two parts. The first part is theory and discussion from US case law, and then we go into the application of civil law through Dr. Salwa. So constructive acceleration is really a very popular concept, has been popular for decades, specifically in the United States. And to just illustrate this point, I'm just sharing with you screenshots from articles that, as I mentioned in my introduction, I'm affiliated with the AAC International. So I've picked a few articles at random that were published in the AAC transactions. So you have this, for example, this article in 1995 about proving and pricing constructive acceleration claims. You have this article about waking the sleeping giant, constructive acceleration from actually, this is in 2005, from which a lot of the material in this presentation has been prepared. You have the basics of construction acceleration by James Zach in 2012, interesting article. who James tries to sort of see how other regions in the world may apply constructive acceleration, because constructive acceleration is predominantly a US concept. And then recently in 2019, we have this article, Understanding and Applying the Elements of Constructive Acceleration. So these are just random articles. And as you can guess, there's a lot of case law that in the US that actually provides a lot of support for these articles in terms of references. So what is constructive acceleration? That's the next sentence. But before that, let's see what are the types of acceleration. So when you have acceleration, we have voluntary acceleration, where the contractor wants to voluntarily accelerate the work so that the contractor can meet at his option, at his choice, the completion date of the project. You have directed acceleration, which this is, I think, what most everyone is familiar with. The employer or the engineer direct the contractor to accelerate the works to meet the contract completion date. And you have constructive acceleration. So our session today focuses on the latter, the constructive acceleration. Now let's take this typical scenario where you have the original contract duration, which spans between the commencement date of the project and the completion date of the project. And as we all know, in all projects, there has to be an act of prevention or a delay. The contractor is delayed, say by the employer, by the engineer. Variation is issued, an unforeseeable condition is encountered. All these events might happen. Of course, they don't happen at that single point. They can happen throughout the project. But let's say that a few days or a few weeks before the contract completion date, we have an act of prevention by the employer, a delay, and that triggers the contractor's submission of an extension of time claim. So the extension of time claim is requesting a certain time, and let's say that the reasonable time that can be extended, let's say there is a reasonable time that can be extended, and that the claim is for a purely excusable event. So it's purely a very legitimate event. It's like a variation, for example. But for some reason, this reasonable extension of time is not granted. Okay, so in that case, the contractor really has no option but to complete in this contractual time period. So the contractor sends a notice of constructive acceleration, so that he says, the contractor is basically in essence saying, I deserve an extension of time to here, but because you did not process my extension of time, you rejected my extension of time, you did not give me that opportunity, so I'm going to finish the contractual completion date. However, I'm reserving my rights for the additional cost, the acceleration that I've encountered. If we zoom in on this issue of reasonable EOT has not been granted, let's say that the contractor submits the EOT claim, and then the engineer receives the claim, and then the engineer does not respond, for example. So might not even be an outright rejection, just a non-response. He just sits on the claim, or he just rejects the claim. And as I mentioned, the claim is a very legitimate claim. And so the contractor would submit a notice, the warning, saying that, okay, you have not responded. I don't have an option but to accelerate. So this is constructive acceleration. Now, in terms of US case law, we have the case of Fairmont, which actually, you can say, sets the conditions that are required for a successful constructive acceleration claim. So there are certain rules that must be followed by the contractor so that the contractor can successfully prove a constructive acceleration claim. So what are these rules or conditions? First, there has to be an existence of a given period of excusable delay. So there is, like I said, it's a legitimate claim. There is a delay, and there is a reasonable time extension that should have been granted. And the contractor submits a notice of delay and request for EOT. Now, if you look at that second condition, what that implies is that if the contract has claims procedures, then these claim procedures must be followed. So if the contractor follows the claim procedures, the contractor submits a notice on time, the contractor submits the particulars on time, submits the claim on time. So we tick the box for that second condition. The third is that there's a failure to grant the requested extension of time within a reasonable time. So, and this issue of within a reasonable time is very important. So it's not just the failure to grant the EOT, it's the failure to act promptly on it. Okay, and even you have sometimes I often hear the argument that the contract does not really have a time limit for the engineer's response to a claim, for example. Well, what's important here, even if it does not have, there's a reasonable time under the circumstances for each case. So if it's not granted in a reasonable time, then that's a rejection, and that can constitute grounds for the contractor to accelerate. Okay. The fourth is that the employer has an order, or the engineer orders the contractor to accelerate. The fifth is that the contractor must prove that there were reasonable efforts by the contractor to accelerate. So it's not just sufficient that we just go through those previous 4 steps and that's it. The contractor must have taken measures to accelerate, must have incurred additional costs to accelerate, even if the efforts were not actually successful. So it doesn't matter if the contractor really achieves the contractual time for completion or not, as long as the contractor exerted the effort to accelerate and incurred additional costs for that, then that would constitute, that would satisfy that last step. And I just have to mention also that some courts in the US, they would not require that all 5 would be met. So a lot of courts require all 5, but some courts in steps, for example, 2 and 3, do not have to be strictly met. So it's not really a set in stone, but these are the 5 core conditions, if you will, for a successful constructive acceleration claim. Now let's look at this fourth one about the employer's order to accelerate. I think the first thing that comes to your mind is that there's an instruction that is issued to the contractor saying, finish the works by the completion date, for example, or accelerate the works. However, that's not necessarily the case. And so that begs the question, so what constitutes an employer's order to accelerate? I mean, the first one we just discussed is a simple request to accelerate. And at this point, I wanted to ask you a question for those who are familiar with the FIDIC contract and use FIDIC contracts. In your opinion, is there an acceleration provision in the FIDIC contract? Let's say the 1999 contract, for example. If you can just take a few seconds and input your feedback in the chat box, that would be appreciated. Just give you a few seconds. I see a lot of no's. Yes, no. Yes. Clause 13, I think. Okay, so we have different. All right. Okay, so Wajid mentions clause 8.6, and he's correct. So actually, if you look at clause 15.6, that's the rate of progress clause provision, and that would be 8.6 in the 1999 contract and 8.7 in the 2017 contract. And if you look, what the clause really says is that if at any point in time the contractor's progress is such that it will not satisfy the contractual completion date, then the engineer may order the contractor to take whatever necessary measures to meet this contract completion date. So whether it be through additional resources, whatever, he takes whatever he can, does whatever he can at his cost and recovers this. But then what's important here, and this is in the 8.7, is this second paragraph that actually mentions that if the contractor is taking these measures, these revised measures, because of factors that are listed in 8.5, or in 1999 is 8.4. So it's for excusable delay events. In that case, that's acceleration. Okay, so actually, that's an order that the instruction given in 8.6 or 8.7 can constitute an order to accelerate, as far as constructive acceleration is concerned, as long as the delay is excusable, as we have mentioned, and as long as, of course, the contractor has submitted the extension of time claim. So we mentioned the request to accelerate. Now, also, if the employer threatens to terminate for default. So say the employer here did not say to the contractor, accelerate. But if the employer says, so the contractor submits the claim, there's no response, or there's a rejection, and then the employer sends a letter saying, which is, of course, I'm sure you know that's very common, saying, contractor, you are late, you are in default, you are now, there may be grounds for termination for default, for example. So the contractor, in fear of termination for default, would just say, I'm accelerating. So that would constitute an order to accelerate. Although it's not really a clear order, it's expressly stated so, but it still constitutes legally a order to accelerate. Similarly, there's a pressure to complete on schedule. I've been in several projects where there are contract provisions that say if the contractor is late, if the progress is late, then the employer can deduct from the contractor's dues in the invoices, for example. And if the employer or the engineer deducts from the contractor's invoices pursuant to that clause, and it's determined or established that the contractors that the reason for the delay is really an excusable event, in that case, and the contractor accelerates, and then in that case, that is also grounds for this is an order to accelerate as well. So that kind of pressure is an order to accelerate. Another kind of pressure is the threat of applying liquidated damages. So the extension of time is submitted, a claim, and it's rejected, and there's a threat to apply LDs, which is, of course, very common as well. That threat to apply LDs also for a legitimate claim is also can constitute grounds for the contractor to constructively accelerate. Now, of course, as we mentioned in the previous slide, delay in granting the EOT. So even if the EOT is the extension of time is granted, but the engineer issues his determination very late, that delay is grounds for a constructive acceleration, because the contractor has to take action quickly. And of course, denial of an extension of time request. So all of these would constitute an order to accelerate. As you can see, not all of them has a direct express instruction to accelerate. Now, let me ask you a question and for this one, we can either let's use the chat box as well. So, can a contractor make a proper claim for constructive acceleration if a non-excusable delay exists at the beginning or the end of the acceleration period? So imagine that in the project we've reached a point where we're nearing the completion date of the project, but the contractor actually is in delay. So the contractor is in delay, and then there is a claim. The contractor submits a claim, and as we have seen, the requirements for constructive acceleration claims are met. However, the fact is that the contractor was late from the beginning. Or the contractor, but even when he takes the acceleration measures, there is still a delay by the contractor. So in that case, would a proper claim for constructive acceleration exist? If you can share your thoughts. I see yes, no. So, okay, I actually see that actually it's interesting, but I see that there's a almost equal, it's a debatable topic. So I have equal yeses and equal no's. So it's a debatable topic, I think. The thing that and actually you're all correct, because really courts have juggled with this question. So we have, for example, the case of Joseph Bennett, in which the contractor really he submitted a time extension claim, but the court found that, of course, as I mentioned, the government, this was against the US government, the government did not grant him the extension of time. However, the court found they had a forensic delay analyst analyze the claims, and the analyst found that the Bennett, the contractor, was entitled to 29 days. But then the delay at the time was 42 days. So there was a substantial delay on the contractor. And what the court said is even if the government had given the extension of time to the contractor, then the contractor would have been late anyway. So then the answer here is no. So the contractor cannot make a proper claim for constructive acceleration if the contractor himself is in delay. But then you have the case of Continental Consolidated Corporation and MSI, where the courts ruled, yes, the contractor can make a claim for constructive acceleration, even if there was a non-excusable delay. In the case of MSI, the delay was at the substantial completion of the project. So by the end of the project, there were still contractor delays. And yet the court ruled that a proper constructive acceleration claim can be made, and that the contractor would be entitled to these costs. In the case of Continental Consolidated Corporation, the delay was at the inception, at the beginning of the constructive acceleration, and the court ruled then that still the contractor can make a proper constructive acceleration claim. So as you can see, courts have been divided on this point. It's a debatable topic. Now I'll leave this in the capable hands of Dr. Salwa to discuss the Egyptian civil law application. Dr. Salwa, over to you.
Thank you, Dr. Walid, for an interesting discussion related to the constructive acceleration concept. In this section, we'll try to bridge the gap between the common law and the civil law systems with respect to the constructive acceleration principle. This principle is not so common in civil law jurisdictions of the MENA region. We will discuss if there are relevant legal principles under the Egyptian civil law on which the argument can be based. Standard forms of contracts are widely being used in the Middle East construction sector. We will examine if the provisions included in such contracts, together with the relevant legal principles, could be used as basis to recover acceleration costs in such situations. The relevant legal principles under the Egyptian civil law, which we contend to be related to constructive acceleration, are external cause, breach of contract, good faith, and proof of damages. The first legal principle under the Egyptian civil law is external cause. According to Article 215 of the Egyptian Civil Code, when specific performance by the debtor is impossible, he will be ordered to pay damages for non-performance of his obligation unless he establishes that the impossibility of performance arose from an external cause beyond his control. The same principle will apply if the debtor is late in the performance of his obligation. So if the works were delayed for a reason for which the contractor is not responsible, and the contractor proves that the delay in performance of such obligation was caused by an external cause beyond his control, the contractor will be exempted from paying damages for failure to fulfill his commitments. The external cause, according to Article 215, could be an act of the employer or delays caused by a neutral event. Furthermore, according to Article 216, the judge may reduce the amount of damages or may even refuse to allow damages if the creditor, by his own fault, has contributed to the cause of or increased the loss. Translating this to a construction setting, if the contractor is delayed due to a reason caused by the employer, the judge may rule that the amount of agreed damages may be reduced or not paid at all by the contractor. These are close to the concept of excusable delay, which is a condition for a constructive acceleration claim. It's noted that under the Egyptian civil law, there is no clear system of claims for extension of time. However, this is more likely regulated in the contract, where in standard forms of contracts, there are extension of time provisions, which include the parties' agreements under a construction contract as to who bears the risk of delay. So Articles 215 and 216 of the Egyptian Civil Code, they have notions that are close to the notion of the extension of time and the excusable delay, which are conditioned for the constructive acceleration. The second relative legal principle under the Egyptian civil law is the breach of contract. It's important to note that under the Egyptian civil law, the non-performance of a contract may occur in different ways. It may be total, partial, or defective performance. Total, for example, where the contractor does not build anything. Partial, contractor executes only part of the work. Or defective performance, for example, delayed work by the contractor or defective works. Both are considered cases of non-performance. In such case of the constructive acceleration, it's more likely to be accepted that the failure or the unreasonable delay by the employer or the engineer, as the case may be, to grant extension of time is a breach of contract by the employer. The third legal principle under the Egyptian civil law is the principle of good faith. Constructive acceleration appears to be in line with a fundamental principle under the civil law, which is the principle of good faith, which provides that contracts must be performed in a manner consistent with the requirements of good faith. This is based on the provisions of Article 148.1, which states that a contract must be performed in accordance with its provisions and in compliance with the requirements of good faith. According to an article by Dr. Muhammad Abdul Wahab, good faith involves certain constraints and positive duties, which inter alia include an obligation to pursue the most suitable method of performance when there are two or more alternative methods, and an obligation to mitigate damage or harm if sustained by either party. In the case at hand, if there is an excusable delay and such delay is compensable, the contractor is normally entitled to prolongation costs. If the contractor chooses to accelerate the works and proves that the acceleration costs are more effective and are less than the prolongation costs, so it would be more effective, more cost effective to choose to accelerate the works than the continued performance and the original rate, and then claim the prolongation cost. At the same time, if the contractor proves to mitigate the damages resulting from the delay in case the contractor does not accelerate the work, then such choice would be in line with the principle of good faith under the Egyptian civil law. Thus, the contractor is under a duty to address risks and to make informed decisions on the basis of good faith and fair dealing. Finally, courts and tribunals examining the merits of the case have the discretion and authority to ascertain the facts of the case and the role good faith may play in respect of the parties' positions on the disputed issues and the circumstances of the case. Last, the fourth relevant legal principle is the proof of damages. As mentioned earlier, it's more likely to be accepted that the failure or unreasonable delay to grant extension of time is a breach of contract by the employer. Such breach of contract would normally entitle the contractor to damages pursuant to Article 215, which states that when specific performance by the debtor is impossible, he will be ordered to pay damages for non-performance of his obligation. Thus, if the contractor faces a constructive acceleration situation and the conditions are fulfilled, and he accelerates and incurs additional costs as a result of such acceleration, such costs incurred to complete within the time for completion would be greater than what would otherwise have been incurred. Accordingly, such damages are a direct result of the breach of contract by the employer. It's important here to note the significance of the notification under the Egyptian civil law. A contractor who accelerates its performance without giving the employer the proper notice may be deemed a volunteer. According to Article 218, subject to any provision to the contrary, damages are not due unless the debtor receives notification requesting him to perform his obligation. Translating this to a constructive acceleration situation, in order for the contractor to be entitled to compensation for damages he incurs as a result of the employer's breach of contract, The contractor is expected to submit the required notice under Article 218. In order for the employer to be notified that such failure for which he is responsible would result in damages to the contractor. So in fact, the notification is required to legally establish that the employer failed to perform his obligation. So let's apply the above legal principles in a constructive acceleration situation. If the contractor proves that there is a delay in the performance of his obligation caused by an external cause beyond his control, or that the contractor is delayed due to a reason caused by the employer, pursuant to Articles 215 and 216. And the contractor submits an extension of time claim as regulated under the contract provisions. And there is a failure by the employer or the engineer, as the case may be, to grant extension of time for which the employer would be held responsible. And the contractor submits the required notice as per the provisions of Article 218 in order to legally establish that the employer failed to perform his obligation, and consequently establish that there is a breach of contract by the employer. The contractor makes an informed decision to accelerate on the basis of good faith. Then the contractor is more likely to be entitled to the damages he incurs as a result of such failure, pursuant to the provisions of Article 215. As this sort of claim will be dealt with in the context of breach of contract, then the claim will most likely have to go to arbitration or litigation for the contractor to recover his acceleration costs. Now the question is, are there other alternative solutions if a contractor finds himself in a constructive acceleration situation? At the beginning, at the offset, if the contractor had succeeded to negotiate the conditions related to constructive acceleration into the contract, the concept shall be applied to such specific contract. Pursuant to the Civil Code principle, the contract is the law of the contracting parties. Article 147.1 of the Egyptian Civil Code. Another option, if there is a failure by the employer or the engineer, as the case may be, to grant extension of time for which the employer is held responsible. The contractor may address this uncertainty at an early stage by referring his claim for extension of time to a dispute board if it exists during the course of the contract, rather than to resort to courts or arbitration. This is probably the right way to go given the problems with acceleration and should typically take a relatively short period of time. A third alternative would be a contractor working on a project governed by the Egyptian civil law who faces a constructive acceleration situation might choose not to accelerate work to attempt to recover the lost time, since the judge has the power to reduce agreed liquidated damages where the employer has contributed to the cause of the loss or when the delay is from an external cause beyond the contractor's control. To wrap up, the legal concept of constructive acceleration is not recognized under the Egyptian civil law as such. However, there are other legal mechanisms a contractor can use to recover acceleration costs in such situation. A contractor facing a constructive acceleration situation probably cannot recover the acceleration costs incurred to recover lost time, but he may be able to recover such additional costs incurred under a breach of contract theory. Now I will hand over the floor to Dr. Walid to discuss the facing delays concept.
Thank you very much, Dr. Salwa, for this very interesting input. By the way, guys, Dr. Salwa and I had some interesting debates actually before the presentation on the civil law, application. I find it actually very interesting, her feedback on the notice, specifically saying that the notice is required by the contractor to establish the damages. That actually opens a whole, if I may say, can of worms as far as notices and claims. Not just I would say not just constructive acceleration, but thank you very much for this valuable input. Now we'll go to pacing delays, and as we have done with constructive acceleration, we'll address it from theory first, U.S. case law, and then we go into application under the Egyptian Civil Code. So now for poll question number 4, I would like you to consider this scenario. Say that there's a 3-year railway construction project that is in place and is nearing completion. And 1 month prior to the completion date of this railway construction project, the employer is still obtaining the required approvals from authorities to secure the operation of the facility. Which is really, it's an all too common thing, at least as I've experienced, that you have a project and then the employer had not really hasn't gotten all the approvals from the authorities in order to operate. So the expected delay is 3 months. So that means 2 months after the contractual completion date. And the contractor decides to slow down progress so that the progress picks up at the end of the 3 months. So you can grasp the scenario. So that there's a delay of 2 months to the contract completion date. The contractor says, okay, I'm slowing everything down and I will pick up again at the end of those 3 months. Okay. So the question here is the contractor considered to be in delay alongside the employer? Is this really a delay by the contractor and a delay by the employer? Thank you, Matt. If you guys can take a minute to provide your input, that will be great.
Sure, well over 100 people here now, so that's getting a good response. People clicking through, almost halfway there. Do a couple more seconds. Wow, pretty close. It's just slowing down now, so one more second. There we go. And here are the results.
Okay, that's great. Actually, we can say that the majority, although it's really a comparable number, 56% and 37%, 56% say that the contractor is in delay, and 37% do not agree with that the contractor that really is not in delay. And 6% are unsure. So let's hold that thought, and before we go into the rest of the presentation. So pacing delays, if you read the literature, they're very closely tied to what's called concurrent delays. Now, concurrent delays would require a whole series of, I think webinars or lectures. But so there's a question, a basic question now. So what is a concurrent delay? Before we go into pacing, to understand what is the concurrent delay. There are 3 main conditions for a concurrent delay. The first one is 2 delays that are occurring at the same time. There are 2 independent events, that means of separate causes, that delay the project. Okay, so and this second point is really, really important. So they are say by independent events of different causes, that means that it's an event caused by a contractor, an event caused by an employer, different causes completely, and each one on its own delays the project. Okay, and when I say delays the project, it delays the longest path to completion. Okay, so now, and one of the tests for this is called the but-for test. So, for example, you say that, okay, if we just to remove the, say, employer's delay for a minute, and let's just focus on the contractor delay. Does this contractor delay affect the longest path to completion on its own? If the answer is yes, then we tick that box, and then that applies. If the employers will do the same thing for the employer's delay, does it delay the project on its own? If we tick that box, then those are concurrent delays. They both affect the longest path to completion, each one independently. And of course, there are different legal responsibilities, which is just another word of saying that the contractor is legally or contractually responsible for that delay. The employer is legally or contractually responsible for that delay. Once all these factors are satisfied, then we have a concurrent delay. And so consider this scenario where we have, the project commencement and the completion. We have a contractor delay, and then of a certain, say, magnitude that affects the longest path to completion. And then we have an employer's delay that starts at exactly the same time and affects the the longest path in the same time as well. Now that, of course, when I say exactly the same time, of course, we know if we're using, the scheduling techniques we're using Primavera, we can't really be absolutely certain that it's exactly the same time. So even if it's comparably very close, then that is a concurrent delay. And that, there's at least two, I think, main references for delay analysis, in my opinion, that are used internationally. We have the AACE's recommended practice 29R-03, and we have also the Society of Construction Laws Delay and Disruption Protocol. Now, this situation that we see on the screen is addressed in AACE as it's called literal concurrency. So it's exactly, they have the exact start time and also the same completion time. SCL, the Society of Construction Law, calls it true concurrent delay. Okay, so, and as the SCL mentions, this is really a very rare occurrence. It's very rare that you have two independent delays that affect exactly, they start at the same time exactly, and they end at the same time. But this is really true concurrent delay. Now, the second situation, which is more common, is that say you have a contractor delay, for example. Of course, as you know, this can be reversed. It's not. I'm not really picking on contractors here, but you can have an employer's delay that that's really the dominant one, for example, and like this in this case. But then after the start of that delay, contractor delay, you have this employer's delay, which also affects the longest path to completion, and there is a gap here between the two delays. And that's really the more common, you can say, concurrent delay situation. And in AACE's terms, this is called functional concurrency. And with the Society of Construction Law, it's just concurrent delay. So they don't have a name for it, except this is really concurrent delay. The first situation is really a very rare event, this true concurrency, but this is really the common concurrent delay thing. Now, I want you to recall that situation that I have posted to you in the beginning of this section about the railway project. And when the contractor chose to slow down the progress, this is called a pacing delay. Now, if that scenario and what we know about concurrency, I want to ask you a question, and also if you can just type in your answers in the chat box. What is the key distinction between concurrent delays, in your opinion, between concurrent delays and pacing delays? And I ask you to provide the answer as one word, just one word. What is the key distinction between both kinds of delays? Just give you a few seconds to respond. Choice, intention, Sarah, John, voluntary, okay, pacing equals notification, choice. Okay. Okay, so again, I think, so who is it? I think it's Wajid, and I think this was also Sarah. But really, the key word is intention. So in the first, in the railway situation, the contractor made a conscious choice that I will reduce the rate of progress. In concurrent delays, that choice is not there. So it's just two independent events that just happened. But in the first one, there was a conscious decision and a clear intent to slow down progress because of that delay. Okay, so that's really the difference between pacing delays and concurrent delays. And let's look at the AACE international definition. In the recommended practice 29R-03, there's this quote that really describes the difference. So the quality that distinguishes pacing from concurrent delays is the fact that pacing is a conscious choice by the performing party with knowledge of the other contemporaneous delay. So the contractor knows about the delay of the authorities, and because of that, the contractor made the conscious choice to reduce the progress. So that constitutes a pacing delay. But in concurrent delays, they occur independently of each other and without a conscious decision to slow down the work. So that's really the difference between them. And what's interesting, and if you look at the STL, if you look at the 2017 edition, you have this in section 15.2, paragraph 15.2, mentions that a contractor may consider pacing activities. So you have that word pacing that are not on the critical path. And it says that the protocol recommends that if the contractor intends to pace non-critical activities, then it should notify the employer and the CA of its intention in this regard. So notify the employer and the CA of its intention. So you have that word again, intention. So really they're saying the same thing. So pacing delays, it's all about intention. And it's all about that link with that other delay, okay? So in an AACE article by John Livingood and Chittick in 2019, a recent article, it illustrates this concept of pacing. So you have here, this is the planned path to completion. And then here's what actually happened. You have an employer's delay that delayed the completion. And then the contractor makes a conscious choice to just pace himself and therefore end at the same time. So that's not a delay. That is the delay. Okay, so this is, but of course, if in the issue of concurrency, you have a different situation. And if you look at the this caption at the end, below the illustration, two parallel critical path delays that do not start at the same time. The second delay was intentionally and consciously slowed because the first delay created float in the network. So this employer's delay created a float in the longest path, and therefore the second delay was able to resume planned production when the first delay ceased. Now this last sentence is very important, and we'll get to it in just a second. Now, if you look at intent, if I ask you now, what if the intent of the contractors was to slow down because of a delay of the other party, as we mentioned, the delay of the, for example, authorities? That is a case of pacing. But if the contractor decides to slow down because the contractor is already is incurring a lot of costs anyway in the project, and he needs to really reduce these costs. So does that account for pacing? Or the other delay is there and everything, but the contractor really wants to reduce the costs. That's really the intention. That's not pacing. So the courts will look into the intent and will and that can make all the difference. Now, the pacing, according to US case law, the pacing party must establish a few things. So the first one, that there was an original delay in the critical path that is caused by the other party. So this is very important. And then that the party claiming pacing contemporaneously and consciously, here's the intent part, slowed its work. And then the slowed work was a response to the other party's delay. And this is another key point, that the party claiming pacing was able to and did resume its original work rate upon the cessation of the first delay. So this is really critical. As you have seen in the previous examples, the contractor, for example, chose to slow down his rate of progress, but then he knows that he's going to pick up at the end of that employer's delay. So then this begs the question. So what if the pacing party was not able to resume upon cessation of the delay? What if this contractor had, slowed down, removed some resources from the site or something, and then by the time the employer got the authorities' approvals, the contractor was not able to get all the resources back. So really what happens then is now the contractor is in delay. So it's not even concurrent. Now the delay of the employer is out, and the contractor is in delay. So the party doing pacing is really taking on a risk. If a contractor intends to pace, then the contractor must be alert that by the time the delay of the employer ends, the contractor is ready to resume work as exactly before the delayed event. So this is a very key point. Now, I'll hand over the floor to Dr. Salwa to discuss the application to the Egyptian civil law.
Thank you, Dr. Wahid. Okay. There's no express principle comparable to such common law principle under the Egyptian civil law. However, there are relevant legal notions and principles under the Egyptian civil law on which the argument can be based. The relevant legal principles under the Egyptian civil law which we contend to be related to placing delays are contribution to the damage, non-performance defense, and good faith. The first legal principle is the contribution to the damage. A notion that could be closed is Article 216. The judge may reduce the amount of damages or may even refuse to allow damages if the creditor, by his own fault, has contributed to the cause of or increased the loss. Reflecting this notion on a case of placing delays, if the employer is delayed, the creditor in such case, and the contractor subsequently faces the delay, the judge may rule that the amount of agreed damages may not be paid by the contractor. The non-performance defense. We mentioned if under the Egyptian civil law, the non-performance of a contract may occur in different ways. It may be total, partial, or defective performance. In the case at hand, the delay by the employer would be considered a defective performance. The Egyptian civil law provides a number of remedies in case of non-performance by a contracting party. One of such remedies is the non-performance defense, or exception non admissibility contractus. This principle is based on Article 161 in bilateral contracts when reciprocal obligations are due. Either of the contracting parties may refrain from performing its obligations if the other party does not perform its obligations. Thus, in a construction contract where correlative obligations are due for performance by the employer and the contractor, either of the contracting parties may refrain from performing his obligation if the other party fails to perform his own obligation. So in our case, if the employer is delayed in performing his obligation, then the contractor may be entitled to refrain from performing his obligation as well. And by refraining from performing the obligation, as we just mentioned, this could include the delay in performing the obligation, which is very close to the notion of facing delay. Certain requirements must be met in order for the non-performance right to be available. Reciprocal obligations to one another should exist in a bilateral contract. Obligations should be due, and the other party must be obliged to perform first. There should be a proportionality between the damage that would injure each party due to the non-performance of the obligation. It's of significance to note that under the non-performance right principle, there is no need for notice. And this is an important point that we need to focus on. It's noted that in order to use this principle, there is no need for the party invoking the principle to give notice to the other party before refraining from performing his obligation, as refraining from making the obligation is deemed enough notification for the other party to perform his obligation. It's not definite that facing delays would not require a notice under the Egyptian civil law. However, invoking a non-performance right principle does not require such notice. It's further left to the contracting party to assess if he will invoke such principle compared to termination, which is left to the judge. That is because the non-performance right principle is less severe than termination. Yet the matter could be escalated to the judge if the other party resorts to court. In such case, the judge would assess the situation and either endorse the defense or reject it. So the contracting party who invokes such defense does not need to resort to court, as is invoking a defense, and the nature of defenses does not require the invoking party to resort to court. The third legal principle under the Egyptian civil law is the principle of good faith. As mentioned in an article, employers often point to contract language requiring the contractor to diligently pursue the work. Employers usually criticize contractors for decisions to face delays, claiming that the contractor is under the obligation to maintain the schedule to the maximum extent decisions relate to a contractor's legal right to face an employer cost delay. For example, float is an available resource to be utilized by all parties in good faith. As mentioned earlier in the constructive acceleration part, good faith is a principle deeply rooted in the Egyptian civil law system. It remains a rich source of rights and obligations. A contractor's right to face delays appears to be in line with the principle of good faith, which is covered under Article 148.1. In an article by Dr. Muhammad Abdul Wahab, as we mentioned, good faith involves certain constraints and positive duties, which inter alia include an obligation to mitigate damage or harm if sustained by either party. Consideration of good faith may be relevant in such case, and the contractor may argue that there is no point in hurrying and waiting when there is an employer cost delay, and thus it would be an act of bad faith not to accept this. That is because if the contractor were to maintain the same rate as planned in the schedule, he would incur unnecessary costs. Thus, the contractor would be mitigating the damage by pacing the delays. Accordingly, it's contended that pacing delays might in fact have a wider acceptance under the civil law because of the principle of good faith. To conclude, constructive acceleration and pacing delays are established principles in common law jurisdictions. In civil law jurisdictions, although the concept do not exist as such, legal principles in civil law jurisdictions could permit the judge or arbitrator a broader discretion to adjust the recoverability of damages under the contract, which is consistent with the basis of the constructive acceleration and pacing delays principle. Thank you for your attention, and now it's time to take questions and comments from the audience. Please type your questions in the Q&A section. Okay, we'll go through them on a first ask, first answer basis.
Dr. Salwa, I just wanted to just mention something regarding the pacing. Again, that's an excellent presentation. Very alarming, this issue of not requiring the notice. I think this is very important. But I was also going to say that this issue of good faith, I think it's a double-edged sword. It can be used actually by both the employer and the contractor in the same way, because the contractor will say, you know, I should not unnecessarily incur costs because of it's your delay, the employer. And the employer can say also that in good faith, you should mitigate any delay. So it's not really up to you to so as we said, that if the contractor does not recover the delay by the end of the employer's delay, then the delay is really the contractor. So the contractor is taking a risk, for example, and the employer can say, well, you know, that risk that you're taking, that can be a form of contrary to good faith because you're not mitigating the delay. And even if it's not mentioned in the contract, that's an implied obligation. So actually, it can be used, I think, interestingly, by both parties. Now over to you with the questions, Dr. Salwa. Thank you.
Thank you. I would like to apologize that we'll only answer the questions that are related to tonight's topic. So could you please just post questions related to constructive acceleration and pacing delays? Okay, we'll start with the first question. How these terms can be aligned with FIDIC contracts, since those are not mentioned in the FIDIC, especially the most common contracts are FIDIC, and I don't believe those terms are available in the law in most of the Middle East countries. Okay, I will direct this question to Walid.
Yeah, the whole purpose of this presentation, that's a very valid remark, and this is exactly why we did this presentation. The terms are not there, but as you can see in both pacing and constructive acceleration, the elements are there. So you can always judge based on the case if constructive acceleration applies or not. You know, and one of the interesting things is although constructive acceleration is really a very I would say very basic really concept. I have not seen a contractor, for example, apply this basic concept. The extension of time and prolongation cost is maybe the most popular remedy, although constructive acceleration is really, I think, would be very equally popular.
Thank you, Dr. Walid. Instead of making constructive acceleration, why cannot the contractor sue the employer or engineer for not determining extension of time or unjustly rejecting? We mentioned in the part related to the application of the facing delays and constructive acceleration under the Egyptian civil law, in specific the part related to constructive acceleration, that there are some alternatives to apply constructive acceleration under the Egyptian civil law. These include resorting to dispute boards, or the contractor might choose not to accelerate and would attempt to recover the lost time by resorting to court or arbitrations, and the judge or arbitrator have the power to reduce the agreed liquidated damages, or the employer has contributed to the cause of the loss, or when the delay is from an external cause beyond the contractor's control. So this would actually depend on the applicable law. There could be alternatives to constructive acceleration under the applicable law of the contract. Okay.
I just wanted to add also that when we say why cannot the contractor sue the employer engineer for terminating, actually this is the core of the lawsuit. So actually this is how it starts. The contractor says, you know, I am suing you because you have unjustly, you know, you did not determine my claim. But then there are two common, you could say, two remedies. Okay, so you're making the lawsuit. So what's the compensation that you want? So the compensation can be that, you know, there's a prolongation cost component. You can go that route, or you can say that, okay, I've accelerated and I want those acceleration costs. So I think that's an integral part. It's not like they're separate. It's an integral part of the claim, the lawsuit.
Thank you, Dr. Walid. Okay, in the railway example where the contractor intended to delay but did not cause any damages as a result, is the contractor still liable for delay damages? Okay, I will direct this question to Walid.
No, the contractor is not would not be considered in delay at all. If the contractor paced and there was managed to pick up the progress by the time the authorities' approval came on board, really the delay is really the employer's. It's not the contractor at all. And the employer does not have a right to apply any liquidated damages. The employer cannot apply that damages on the contractor.
Thank you. I just want to make sure, is the delay by the employer or contractor considered a non-performance under the Egyptian civil law? Yes, in fact, according to Dr. Abdelrazak Sanhouri, the definition of non-performance under the Egyptian civil law is broader than mere total non-performance. It could be total, partial, or defective. And we noted that defective performance would include delayed works or defective works. So the delay by the employer or the contractor would be considered a non-performance under the Egyptian civil law.
I just want to add, say that Dr. Rania's question is very interesting because Dr. Salwa and I had debates on this very topic. So I mean, the issue of non-performance, I was telling her, doesn't that conflict with pacing? I mean, in pacing, the contractor is performing. It's not like it's not performing. But as Dr. Salwa just explained, non-performance, as the name, maybe the name is a bit misleading, but it does include defective performance. Defective performance does have to do with delay. So that's thank you, Dr. Salwa, for this clarification.
If the contractor intends to delay due to delay by the employer, which resulted in an overall reduction in cost, does this still count as pacing delay? The intent here was to pace the works. The cost saving was just a result of this. Okay, Dr. Walid, I'll direct this question to you.
Let me read again. It's my attention to I would say that I'm sorry, just
the question by Sarah Jones.
Yeah, I don't No, I would not. I would not say that. That's an interesting question, actually. I'm not sure of the answer, but I would argue that I would argue not. But that's an interesting question. Not really sure. That would be an interesting argument to put forward.
Okay. Can pacing delays be claimed as a base of liquidated damages application by the employer if the contractor delay exceeds the employer's? Okay, is this question clear to you?
Yeah, I think so the contractor's delay exceeds the employer's, and the contractor intended to pace. So I would argue, well, that puts an interesting thing, Dr. Salwa, because I think for liquidated damages to be applicable, there should be an extended date. I wonder what you think of this in terms of the Egyptian civil law. So the contractor intends to pace, but the contractor took the risk, and now the contractor is late. But then say we don't have an extended time for completion. So can the employer apply liquidated damages on the contractor, because now the contractor is the one who's late? What do you think of that?
In such case, of course, at the beginning, we'll have to establish the time for completion, the extended time for completion, in order to apply the liquidated damages. So even if the employer chooses, or if the employer actually grants extension of time, or the engineer, and then it's found that the contractor's delay exceeded the employer's, then the employer will apply liquidated damages. If the employer does not grant extension of time, okay, and applies liquidated damages, then the contractor will have to resort to court or arbitration and submit his claim for extension of time. And afterwards, he would claim, he would ask to, according to the claim to the result of the granted extension of time, it would be clear what liquidated damages are applicable and what not. And since the contractor's delay exceeds the employer's, then there would be liquidated damages for delay. It would be applicable. Under the Egyptian civil law, the liquidated damages clause would not drop just because there is no granting of extension of time. This is different from the concept of time at large under the common law. So the liquidated damages clause will still exist and will be applicable in court. However, the question would be, what would be the amount of liquidated damages depending on the delay by the contractor, which might be resolved in court or arbitration if it's not resolved on site by the engineer or the employer. Okay. Moving to the next question, if a notice is not required, it would help to inform the other party of the intention and facilitate proving the case afterwards. If the question here is tackling the issue of the non-performance defense, where the notice is not required, defenses under the Egyptian civil law in general do not require notices. Okay, but of course it would be helpful to submit such notice in order to draw the other party's attention to the intention of the contractor, in such case to pace the delays. However, it's not a requirement for the defense itself. As we mentioned, it could be debated if the pacing the delays itself would require a notice or not, but the non-performance defense would not require a notice. Does pacing delay require an approval from the consultant? Will it affect my right to get prolongation costs? I'll direct this question to you, Ali.
No, I don't think, and it doesn't depend on approval by the consultant at all. It's this is, as we've mentioned, it's a clearly contractor's intent. That's really a distinguishing factor. But the most important thing for the contractor to establish is this intention. So does not have to get any approval from the consultant. He just simply has to say that you're in delay. I'm letting you know that I am pacing, I'm reducing, I'm slowing down work, and I will pick up, at the right time before the delay ceases, for example. It does not require any approval from the consultant. And I don't think liquidated damages are applicable at all. As we mentioned, this takes us to the previous question.
You mentioned that a notice required by the Egyptian civil law for constructive acceleration. So will that notice have a time bar? No, the notice wouldn't have a time bar under the Egyptian civil law because it's not a requirement under Article 218. It's just, it states that in order to, it states that subject to any provision to the contrary, damages are not due unless the debtor receives notification requesting him to perform his obligation. What will be considered a reasonable time? Actually, the notice establishes that the employer failed to perform his obligation. So it's definitely a condition precedent to the contractor's action of acceleration itself. So it has to be before the acceleration. Is it required to be served before implementing construction? Please go ahead.
Yeah, I just add that I mean if you like, if we analyze the situation, the contractor submits an extension of time claim and he doesn't get a response in 2 or 3 weeks, or he gets a rejection. So a reasonable time should really be shortly after this rejection, or say, for example, 3 or 4 weeks maximum from the non-response. So if the contractor waits for 2 months or 3 months, that's not really a reasonable time. So it depends on the circumstances, but I think these would be rough estimates.
Yes, and actually, regarding the question, is it required? Can it be served at the end of the project and the contractor claim acceleration cost? This would not be possible under Article 218 because the purpose of the notification under Article 218 is to request the employer to perform his obligation, which is to grant extension of time. Accordingly, it cannot be served at the end of the project. In case the contractor decides to carry out, actually we're running out of time, so this is going to be the last question that we can take. In case the contractor decides to carry out facing delay and is unable to resume when the employer delay ends, like Dr. Walid mentioned, if the contractor still manages to complete the works within the revised completion date after the employer delay, will this still count as a contractor delay? I'll direct this question to Walid.
Yeah, as long as the contractor manages to complete within the revised completion date, then there's definitely no delay. I mean, this question assumes that there is an extension of time that was granted, there's a revised completion date. And so if the contractor managed to complete before then that's the benchmark. So then you cannot say that the contractor is in delay, although the contractor is delayed in delay in terms of the pacing event, but that means that the contractor did not delay, his delay did not affect the revised critical path, so to speak. So therefore, it would not be considered, in my opinion, in delay.
Thank you, Dr. Walid. Thank you for your attention and for such interactive discussion and comments. You've been a wonderful audience. I'll hand over to Matt.
Yeah, thank you, Dr. Salwa. Thank you, Dr. Walid. Really good to see that volume of questions going through. I can really see the appetite for the topic here. So thank you very much for handling so many. You've done a fantastic job. Kept you working for an hour and a half here tonight. We really do appreciate it here at the CIOB. Really just to say thank you very much to the audience as well for tuning in. We're really grateful to be breaking new ground, particularly in Egypt, with a lot of the new companies that we're following and collaborating with. If you've got any comments for Dr. Salwa and Dr. Walid, please put them on the chat now. I'm guessing that we would probably like to see you guys back again, maybe to talk about something else. You'll always be welcome. And on behalf of the Abu Dhabi Hub Committee, we'd like to say thank you very much. So yeah, thanks again for taking up your evening to support us here.
Thank you all. Thank you, CIOB. Thank you, Dr. Salwa. Thank you for all the attendees. This was really an enjoyable presentation and interactive discussion. Thank you very much.
And I should probably just close with, we will send a recording. We will have a PDF of the presentation, and will be accessible and in touch for you if you have any further questions. But yeah, some good comments, great presentation, enlightening, great session. a few other things coming in. Yeah, really enjoyable. So thank you very much, everyone. And I bid you a very good evening until the next time. See you soon.
Thank you.
Bye-bye.
Thank you. Okay.
Wonderful evening. Bye-bye.